set aside the default is denied. One, it was not filed within 21 days of the entry of the default. Two, although defendant did not have actual notice, he had legal notice. And
I'm sorry?
you're here on your own.
Oh, yes.
This is a motion that you filed regarding a request to set aside a default judgment. The case has got a bit of a tortured history, but Portfolio Recovery Associates sued you in this file, 251870. They sued for $3,134.75 plus costs. And in April 2nd of 2026, a judgment entered against you in the amount of $3,286.27. You filed a letter with the court and a motion to set aside the default on May 13th. That was more than 21 days after the entry of the default, but you contend that you were not ever served with this action and essentially that you've already paid the debt. So you have two contentions. One, that the debt is already paid, and two, that you didn't get proper notice. You were served by alternative service. They made multiple efforts to serve you. The process server said the defendant is evading service. We asked for an additional time. So they got more time. I did a second summons, and they did an alternative service by sending it to the Thomas Street address and tacking it to the Thomas Street address. However, apparently it's your contention that you were no longer living there and never actually got notice. You also contend that you've already paid it. So, Mr. Sawyer, you made the motion for me to set aside the default. What do you want me to know?
I never got the summons because I had moved prior the year of 2025, and October 31st was my last day in those the apartments on the Thomas Street. And the debt was paid years ago by my bank through a debt consolidation through my bank that offered it, and the sum of $2,500 and some dollars was sent to Capital One, which was the original creditor, and I have proof that that check was in fact cashed or deposited by Capital One.
All right. So we know you don't have actual notice. You moved in October of 2025. They were trying to serve you in January. And he says you were evading service. Well, you're not really evading service. You don't live there anymore. So we posted it and mailed it to that address that you were no longer living at. It doesn't appear you've done anything to forward your address or change your address with the postal service. First attempt, December 2nd. Second attempt, December 7th. Neighbor states defendant still lives at that address. Neighbor states defendant still lives at that address. Relative occupant, anyway, I'm not sure what it meant. they couldn't find you and they were trying to serve you at some place you never lived at. So there is a bit of an issue with the service, but the other issue is more than 21 days have passed since the default entered. You have to have a couple of reasons to set aside a default. You have to show a good reason for failing to respond to the summons. In your case, it's because you didn't know about it. And secondly, you have to have a meritorious defense. And your meritorious defense is that you allege you've already paid the bill. So you may actually hit both prongs of the motion to set aside the default. Mr. Kirschenheiter, what's your position?
Well, Judge, I think as to the meritorious defense, I can appreciate defendant maybe thinking this was paid. However, I'm looking at statements after the payment that was defendant has stated he made. There was more transactions, more cash advances, and more payments. Defendant continued to pay and use this account for months after the supposed payment and supposed to pay off the debt. Defendant made a payment on the account of $125 in May of 2022. The $2,500 or so payment was from December of 21. So the account was continued to be used. Statements were sent to defendant's address, and there were payments continued to be made on the account. Defendant continued to make transactions and take cash advances. So there is still a balance to knowing, and I do believe that the plaintiff is entitled to judgment. I can't speak to actual notice. I will note, like the court indicated, it has been past 21 days, but he was served according to the court rules, but I can't speak to whether or not he
has. Yeah, there's a couple things. There's legal notice and there's actual notice. Mr. Kirschenheiter contends that you had legal notice. They had an order for alternative service. You had moved and apparently didn't leave any forwarding address. One of the things you're supposed to do when you vacate is turn in your keys and give your forwarding address in writing within 4 days of your moving. And they apparently weren't able to get any other address. As a practical matter, you were only a couple blocks away. You were probably 500 yards from where you were to where you are now. But they didn't know that. They made multiple efforts to try to locate you, and they got a lawful order for alternative service, which they filed. Secondly, you have some unsubstantiated claim that you paid this in your letter. You say, you have a couple of documents that you attached. Boy, very hard to read. From 2021 to the company. However, he contends that you continued to use the card in 2022 and made additional cash advances and additional charges. So your information may be accurate that you did make those payments, but then you ran up additional charges after that. So this case was never resolved. It never resulted in a lawsuit until this case was filed for collection. So you had made some settlement of previous debt, but then you continued to accrue more debt.
I'm not exactly sure how that's possible because when I faulted on the credit card, the Capital One turned off the card so I can no longer use it.
All right, well, let's see what I can see here. October 21 of 2022. We've got some Capital One Quicksilver account. April of 20 to May of 20, it shows McDonald's, Walmart, Crunchyroll, PlayStation Network in April and May. It shows other charges in 2022 at the address of apartment 2, 617 Thomas Street. Cash advance, $650. I'm not sure if that's accurate. Maybe that was the limit for a cash advance. Of course, then each month, late fees, interest accrue. So as of November of 2022, the amount due was $3,134.75. Then they charged it off and sold the debt to Portfolio Recovery Associates. Yeah, you made these payments in 2021, and their documentation clearly shows there were charges made in this card at least as recently as May of 2022. The motion to set aside the default is denied. One, it was not filed within 21 days of the entry of default. Two, although defendant did not have actual notice, he had legal notice. And three, your meritorious defense does not stand up under the exhibits that were filed. And again, this is about 5 years ago, so it's hard to recall everything. But your checks show payments in 2021, and their account shows charges were still being made in 2022. So the balance increased after you maybe got it resolved. They didn't shut it off. So for all three reasons, your motion to set aside the default is denied and the debt remains.
Did you need an order, Judge?
I have one here somewhere.
Okay.
Now, the next question is, maybe you can set up some sort of a repayment agreement or something. Mr. Kirschenheiter, are you willing to speak to the defendant?
I do have some time now, yeah.
All right, let me see if I can open another breakout room. I'm not the most adept at this. All right, I'm going to put you in a room where you can speak privately with Mr. Kirschenheiter, but I've denied your motion. The debt remains in the amount of the judgment, $3,286.27. And I'll let you guys talk. You're both here at the same time. It doesn't hurt anything. So Mr. Sawyer, you join breakout room, hit the button that says join.